Sherpa, the Director of the Judiciary Academy, my colleague, Mr. Jagat Rai, the District Judge, Namchi, police officers here, the Deputy Director, Ms. Janam, who is also the Chief in the cadre of Chief Judicial Magistrate and Senior Civil Judge, and I believe some of the other members who are present here are from the insurance company. I welcome you all and thank the Academy for giving me this opportunity to be with you all today. It's quite an angle that I have to face, not this side because there is nobody here, but almost to the right side. Nevertheless, before I begin, because there are very few of you, may I have an introduction so that I could modulate my topic accordingly. I think we don't need a mic, but the two of you in the front, I already know Ms. Janu and Sharon, I already know. The others may. Yes, please, could you introduce yourselves from any centers?
I'm Sonam Chetri, Deputy President of RTU Canton. I'm Sonam and Bhutia, MBA Canton.
So I'm Shinjapa, MBA Canton. What are we Inspector Canton?
Rivers Right, MBA.
Sorry, sir.
Rivers Right, MBA Canton. So good morning. I'm Yogindra Gurela, Motor Vehicle Inspector, Singtam.
Singtam. Yes, sir.
Sumit Chetri from Singtam.
Motor vehicle? Inspector?
No, sir, driver.
Sorry?
Driver.
Sorry?
Driver.
Driver. Okay. Yes.
Gurnaam Singh from New India Assurance Company.
New India Insurance. Yes, sir.
Sir, I'm Amol Chetri, National Assistant Manager.
National Insurance Company. Yes.
Good morning, sir. Sonam Bhutia, Sub Inspector Southern Police.
Yes. Salute is not required, sir. Please introduce you. Please be formal.
Good morning, sir.
Yes.
I'm SI Hon'ble from Southern Police. No, sir. My name is Hon'ble from Southern Police.
Okay.
Morning, sir. I'm Deepshika Guru. I'm ART from Pakyong. ART.
Good morning, sir. I'm Lakshmi Sarna, MBA Pakyong.
Okay.
Morning, sir. I'm Sonam Bhutia, MBA Pakyong.
Participants from the Motor Vehicle Department, my colleagues from the court, and from the Police Investigating Agency, and also from the insurance company. There appears to be nobody from Mangan and Namchi district and Sorin district, but nevertheless, I think the major stakeholders are already here, and we will try to discuss the topic for the day. The topic that has been assigned is an orientation program. According to the schedule, it was special orientation program, but I deleted the word special. So if you can give me kind permission, because I think it will just be an orientation program amongst the stakeholders about what? About the Motor Vehicle Act, which more than me, all of you, I am sure, are already aware of. Nevertheless, I would try to give you some aspect of the Motor Vehicle Act, the amendment of 2019, which is quite an important amendment, vis-a-vis the CNB rules amended by the 2022 amendment. These are, I think, very, very important so far as the present motor vehicle legislation in India is concerned. You know, perhaps about 6 months ago, we had one outstanding resource person from Faridabad, if I am not mistaken, Dr. Rohit Baluja. Dr. Rohit Baluja, he prepared a compilation, which I normally refer to. He has given a comparative chart as well as the latest amendment to the Motor Vehicle Act. And he says in this compilation that there are about 150,000 fatalities and an estimated of 2.6 million serious injuries every year. And do you know, I'm sure the RTOs here are aware, there are about 300 million registered motor vehicle in India, and annually it increases up to by 10%, which roughly translates to 25 to 30 million every year. And there are new licenses issued accordingly. Now, why did I refer to these facts and these figures? Is that the enormity of the number of motor vehicles that are on road today in India is too many. Look at Gangtok, for example, or look at your own district even in our state. I'm sure all of you will agree with me that over the past 10 to 15 years, the increase in the number of motor vehicles registered in Sikkim has grown manifold. What happens when there are a number of motor vehicles on the road? Traffic congestion, number one. Number two, possibility of accidents. And number three, many riders, new as well as learners, coming to the road. Now, in order to regulate all this and in order to control, what is required is that the law or the legislation should go hand in hand with the present requirement of time. To understand the Motor Vehicles Act of 1988, I will take you briefly a little back to the history of the Motor Vehicles Act. So you will all perhaps already know that the first Motor Vehicle Act in India was pre-independence, 1914. This was the central legislation of British India at that time, and many princely states also adopted with some modifications. Now, why was this 1914 Act required? This 1914 Act, which if you see the net, it says that there are 18 sections, but I was just going through, just yesterday I was just going through, and I found that there were 19 sections, because one of the sections was the repealing section, section 19. So practically you can say that there were 18 sections, and it was required because in the end of the 19th century there were vehicles that were introduced in the Indian roads. Now, to regulate the movement of vehicles, this legislation was required. There were two amendments in 1920 and 1924. Before it gave way to the other Motor Vehicles Act of the 1939. This 1939 is another pre-independence legislation of the motor vehicles. Why was this required? This was required to take care of the situation at that time. Even in 1939, compared
May I come in?
Yes. Yes, sir. So what I was saying is, compared to the 1914 Act, with two amendments, 1939 was required because they had to bring about certain modifications, certain changes due to the requirement of the number of vehicles increasing every year. Now, interestingly, if you see the present Motor Vehicle Act of 1988, some of the important provisions which is still existent in the 1988 Act was already there in the 1939 Act. Number one, for all of you, and especially for the courts, is the constitution of the Motor Accidents Claim Tribunal. The 1939 Act already had a provision for constitution of the Claims Tribunal. Section 110. Now, how do you apply for compensation? Presently, all over India, the provision that is invoked for the claim application by the legal heirs, by the legal representatives of the deceased, or even the injured persons, is either 166 or 164 after the amendment of 2019. Before 2019, it was 163A. My worthy colleagues here will agree with me. And if you see, at that time of 1939, even then, there was already a provision of 110A. Most of the provisions are almost same. If you see 166 of the present Act and the 110A of the 1939 Act, with minor modifications, tweaks here and there. I will come to one of the important provision of 166, which is limitation, at a little later point in time. But you will understand that even under 1110A of the 1939 Act, there already was a provision for limitation. Now, how much was the limitation? Like the one we have it right now, 6 months from the date of the accident. A claim has to be filed within 6 months from the date of accident. That is the present law so far as limitation is concerned for motor vehicles. We will discuss it a little later. But 110A also had a proviso that if there was some genuine reason which the claims tribunal was satisfied, then even if the claim was beyond 6 months, the claim application could be registered. This was the law, which ultimately the proviso was deleted by the 2019 Act. And we will deal with that a little later when I discuss about the cases. So let us go back to our 1939 Act. Now this 1939 Act also seemed a little less for the time after independence, after 1947. It gave way to the 1988 or the present Motor Vehicle Act. Now what was the need? The need was because of the account in the change in road transport, the pattern of passengers as well as freight vehicle movements, the development of the road network, the introduction of the national highways, and to manage these vehicular movement, it was required that the 1988 Act had to come, and therefore there was a working group which was constituted in 1984. Perhaps you may find this a little, maybe a little out of place, but I assure you, sir, madam, that to understand any legislation, I think it is very important to go back to the history, to understand why it was there, and why there was a change required. And why do we have the present Motor Vehicle Act of 1988 with the latest amendment of 2019? Now the working group that was constituted in 1984, they had to submit a draft proposal. They took into consideration the objections, the suggestions given by every state, every stakeholders. And they also took into account, at that time, the decision of the Hon'ble Supreme Court in this particular case of Guni Muhammad of 1987, where the Hon'ble Supreme Court of India said that you have to raise the limit of compensation that is payable in respect of death and permanent disablement. All these provisions were taken into account, and the 1988 bill was introduced. And what was the object? The object of the 1988 to bring the 1988 Act was to implement strict procedure for licensing authority, the validity period, to ensure road safety, to manage the rapid number of personal as well as commercial vehicle on the road, increase in the quantum of compensation, and to remove the time limit so far traffic accident compensation is concerned. And these are only some of the objects that I have put it here, but these are the important objects of bringing the 1988 Act. Now the 1988 Act, there were amendments before 2019 Act also. And if you see, there were about 3 amendments before the 2019 present amendment. One in 94, one in 2000, one in 2001, and the present, the latest one which we have is the 2019 Act. The present law of 2019, the Parliament had to discuss why there should be an amendment, right? And it is for the minister of that particular ministry to move the bill. So this bill was moved in the Lok Sabha first on the 15th of July 2019 by Sri Nitin Gadkari, the Minister for Road and Transport, as well as Highways, and came into force from 1st September 2019. What are the changes that are brought about by the 2019 amendment? I'm sure, because all of you are the stakeholders, and I'm sure you must have gone through the 2019 Amendment Act. There is quite a drastic change, many changes that has been brought about. And some of these I would like to highlight is number one, the compensation for road accidents. Now what was the compensation? One is the scheme for cashless treatment of the road victims. Now during that golden hour. Now what is a golden hour? The term golden hour, okay, please come sir. The police stations which are located in the highways, Rampur, Singtam, and Manli, these are street highways where there are a number of accidents. I wish that there could have been some police officers from North as well, because there are a lot of tourist vehicles going to the North District, and we come across a lot of this kind of, on the social media, the news about motor vehicle accidents in North Sikkim. And if you open your social media, even now, you will see Gadi Ka Tokyo Day, there has been some accident. And if you see even Siliguri, there are a number of accidents. And therefore, what is one thing is this golden hour. Now what is this golden hour? A golden hour, when it's a key bujno sir. The answer is here itself. Golden hour, Banu Matlab, it is defined under the 2019 amendment. It is that particular hour, 1 hour after the accident, where there is maximum possibility of that person or that victim surviving an accident. You all have been there, you have seen accidents, and I'm sure you must have been, in many cases, the first responders. You must have gone to there, you must have taken the victim, removed them from the place of accident and taken them to the hospital. Third, what happens if there is no response within this golden hour? The possibility of the victim dying is imminent. So this is one provision I think is going to make a lot of difference in a place like India, where there are accidents, every day on the highways. And why are there accidents? Because, number one, there is no sense of following the traffic rules and regulations. Number two, many of them are drunk drivers. Number three, people who are not eligible for licenses, they get fake licenses. These are some of the reasons why there are so many accidents in our country. And cashless facility, I think, will make a big difference if it is implemented in its proper perspective. So far as this cashless facility is concerned, there is already a matter pending before the Hon'ble Supreme Court, which I will deal with at the end when we discuss about the cases. And if the central government takes out this scheme in its proper perspective, it is going to save a lot of lives. Now, what are the other changes? Interim relief, increase in minimum compensation in hit and run cases. Rajuko topic ma hit and run kuni थियो. Now, what does hit and run means? What does it mean? What do you understand by hit and run? तपाईहरुले के बुझ्नुहुन्छ hit and run case ma? हजुरले कसैले भन्नुहोस् न त, हैन? Let us have a sort of an interactive program भनेको नि त.
It's a ministry or something. If you have found the pricing,
Yes.
then maybe you think there's a return case.
Absolutely right. Right? Yeah, police officers are like, keep us hit and run. Absolutely right. Right? A hit and run case is that kind of case where the driver of that offending vehicle or that offending vehicle is not known. On the highway or any road, public road, but you cannot trace who is that perpetrator. One night, when you go on patrolling, you will see somebody lying on the road, but you do not know who hit that person. One truck passing through may have just hit him and fled away from that road. Now that person is unconscious. As a first responder, what do? You take him to the nearest hospital, get him admitted there. Most of the time, by the time you go there, that person is already dead or is in the verge of dying. So most of the time, what we see in the court is the NLC form, or the doctors would say, brought dead. Right? So these are the hit and run cases. So there are provisions in this particular amendment where the amount of compensation for hit and run, it has also been increased from 25,000 to 2 lakhs, and for injury cases up to 50,000. Now, what is the second other major development in the 2019 Act is compulsory insurance. What does it mean? It means that the central government will have to constitute a motor vehicle accident fund. Why do we need this fund? You fund like this fund is required to provide treatment for those persons in the scheme of golden hour, cashless treatment. What is the cashless treatment? There are many private hospitals who will say that, sorry, we will not, without payment, we can only do up to the first aid or the first response. Thereafter, who will pay for the expenses if he undergoes treatment for the next 6 months or the next 1 month? And in cases like hit and run, you are unable to trace that vehicle at all. but the person is already dead. The family require compensation. Who is going to pay? It has to come from the accident fund. For treatment of persons, for compensation in grievous injuries, in death, and others which are prescribed by the central government. Now, what are the other changes that has been brought about by the 2019 Act is in our country, there is also no dearth of good people. With good intention, people go and try to help the victims of road accident. But you know what the majority of these kind of people tell that their experience was? They would say that we will never, I think it's better to avoid, we will never go to the police station. I'm sorry, there are police officers here, but that is a common these are in the minds of a common man. They don't want to, they want to avoid police stations so far as possible. Kina, Bani, whether you are the person who hit this fellow, that is the reason why you brought him to the hospital. Unnecessary harassment here. Come tomorrow, your statement will be recorded. Persi almost, Holy Pata almost. So what happens is these good Samaritans will feel harassed. No, we will avoid going to police stations. We will avoid going to courts. When there is an accident, majority of the people, they will just avoid. Many times on the road you go to Siliguri, there is this stretch called Sivok, which is quite a good road, a plain, when we enter Siliguri. So people tend to drive fast. And there are a number of accidents here. And mostly it involves vehicles from the hills. And there's a huge jam. But people will try to avoid. Chitto nikale yaबाट निकाले हैन त्यस्तो झन्झट हुँदैन. मान्छे लडिरहेको हुन्छ on the road. हैन बस पल्टिरहेको हुन्छ. But people avoid helping. You know why? Because of this harassment. Now in order to curb this and in order to save life, how can we save life? How can we have this good in our brought into reality is if there is somebody who can bring this victim to the hospital within the period of 1 hour of the accident. तर त्यो मान्छेलाई harass गर्न थाल्यो भने त भएन नि. So the parliament in its wisdom saw that good Samaritans they have to be protected. र अहिलेको के छ भन्दाखेरि in case of emergency, in good faith, if you have done it voluntarily and without any expectation of prize, if you have brought that person, because of many of your, if there are some genuine mistakes, you will not be held accountable. So this is in order to encourage people to help road accident victims. This is one major amendment. I think till now, this cashless treatment, this will be very, very helpful. And if this is also implemented in its proper perspective, a lot of lives will be saved. Now, what is the other amendment? The recall of vehicles. Particular faulty garis are, it affects the environment. It is not safe for passengers. The central government has the power under the new amendment of 2019 to recall these vehicles. And if the vehicles are recalled, what happens? If the vehicles are recalled. If the vehicles are recalled, the question will be, what about the buyers? Because that consumer has collected a lot of fund either by savings or borrowing or by taking a loan and you purchase a vehicle. The central government takes a decision to recall because of these factors. What happens? The manufacturer will have to compensate the genuine buyers in such cases. So this is one of the amendments that has been brought about. The other amendment that has been brought about is the National Transportation Policy. I'm sure you must have all already gone through, and many of these are also implemented in our state. To develop a national transportation policy for what? To establish planning framework for road transport, permit को कतिवटा policies बनाउनु, and many other things which are required under this particular policy. Now, there is also a requirement of the constitution of the Road Safety Board. Why do we require a Road Safety Board?
National Road Safety Board is required to advise the central as well as state government on what standard of motor vehicle the Road Safety Board will take into consideration all these registration of licenses, standard of road safety, and so on and so forth. The other aspect which the 2019 Amendment Act has brought about a change is on penalties. People would say that don't wear a helmet. How much are they going to charge? 100 rupees, 200 rupees, 500 rupees. Why not? Or wearing a seat belt is not compulsory. Why do we do it? The situation was such that the road accidents and traffic violations were increasing every year. So they had to bring about some changes on penalties and offences. These are some of the examples, not everything, but some of the examples are increasing drunk driving from 2,000 rupees to 10,000.
These are some of the penalties that has been increased by the amendment. Now, moving on with the times, the present time, what happens is whenever you go out, we don't have it right now in Sikkim, but I've seen very recently in Bagdogra, I saw just outside the airport that there was a board for Uber taxis. Some of you may have noticed who have gone to Bagdogra recently. But whenever you go to metropolitan cities like Delhi, Calcutta, anywhere, you would like to book your taxi, your cab. Uber, Ola, these are some of the prominent taxi apps that is prevalent in our country, and these are known as taxi aggregators. Now, a provision has been inserted in the 2019 Act to regulate these kind of app taxis. But what they have to do is they will have to comply with the IT Act of 2000. And these are known as aggregators, the taxi aggregators. So this is one important provision which has also been incorporated in 2019 Act. And I think the reason is because we have to move along with the times. We cannot be laid back. IT, in all spheres of life, it is moving at us, I think, in a very high pace. And in order to catch up, the Motor Vehicle Act of 1988 with this amendment of 2019 has also got this taxi aggregators as one of the provision for amendment. Now the other thing is, what happens is, in order to register your vehicle, you have to go to a registering authority. The licensing, for licenses, you have to go to the licensing authority. By this amendment, these provisions have been, some of the provisions have been incorporated so that there can be a national register for licenses. The registration can be effected from the dealership themselves. You don't need to go to the motor vehicle office. And you can even apply for your licenses online. So this is another amendment which has come about, the National Register for Driving License and Registration Certificate. See, over the span of these many years where I have dealt with, as a magistrate, before the BNS came in 2023, we had IPC, Ranile 279 IPC, that is rash and negligent driving, 337, 338, 304A of the IPC, whatever. These were ingrained as a magistrate. Now after I started dealing with the Motor Vehicles Act, or MACT in the Tribunal, I deal with a lot of applications under 164 and 166 of the present 1988 Act for compensation. And one of the objections in the tribunal, claim tribunal, from the insurance company is driving licenses. The offending vehicle or the person driving the car or the vehicle did not have a valid driving license. This is one objection. 279, 337, Motor Vehicle Act company provisions are this person drove rashly, negligently, and he did not have a valid driving license. And why was this? Because many of them have taken out fake licenses. But how many of you who have heard about driving licenses from Zoni Botu? I don't know if I'm pronouncing right. Zoni Botu. Zoni Botu. I think this is a place in Nagaland. And most of the fake licenses, I don't mean to talk about the place, but what I'm saying is in this context, fake licenses that come to the court, and I've seen one thing in common is that there are licenses from Zoni Botu. And at the end, when we complete our trial, we find that these are fake licenses. Now with the National Register, it is, I think, going to curb issuance of this fake licenses because you can verify it through your online app, Vahansa, Saritisa, So this is another milestone which 2019 Amendment Act will achieve by this particular amendment. Now another thing is the training of drivers. It is not that we do not have training academies, training schools. Even if you go out in a radius of 5 kilometers from here, you will find 1 or 2 motor driving institutes. But we don't have qualified commercial drivers in India. So keeping note of this 2019 Amendment Act also takes into consideration the opening of more training institutes so that they could have a better commercial drivers. As I already said, online driving licenses. You can apply for online driving licenses, and the validity period has also increased from 3 to 5 years. So I think this is quite convenient for the drivers, for the consumers. They don't need to renew it every time, because renewal, I'm talking not from the perspective of an RTO or from the perspective of the officer of the state government, but I'm talking from the perspective of a consumer, of a common man. The moment you go to an office for renewal, first thing is you need to pay money. Pay money in what sense? You need to pay the required licensing or renewal fees. I know that you need to go and take out bank receipts. Bank receipts, each state, even in our state we have, and this is the receipt that you need to bring it from the State Bank of Sikkim for renewal of your license or for renewal of your registration certificate. So if you increase it from 3 to 5 years, you'll save not only your time, I think these kind of expenses, unnecessary expenses will also be, this will also be addressed. Now, so far as these are concerned, I have given you a brief outline of what are the changes brought about by the 2019 Amendment Act for the 1988 Motor Vehicles Act. Before I proceed to the rules, do you have any question? कसैलाई केही भन्नु छ? Hit and run cases, compensation mechanisms have also been discussed. And now let us go to the changes introduced by the Central Motor Vehicle. That was introduced in the Central Motor Vehicle Rules of 2022. One of the important provision that has changed is how an investigation is to be conducted now. What is the role of an investigating officer? And what are the roles of the nodal officer of the insurance company, the registering officers, vis-a-vis the claims tribunal? They have all been brought together in one common platform, and this particular change is, I think, phenomenal. If you use it in a proper perspective, it will help a great deal for dealing in motor vehicle accident claims cases. One of the change, before I deal with the investigation, is this particular safety measure. This is one change, where in two-wheelers, if you are riding with a child of between 9 months to 4 years, you use your safety harness. The 150A, Rule 150A is very, very important. I think it is one of the longest rule, amended longest rule, and this will give a comprehensive information as to how to deal with motor accident cases. What does it say? Is that whenever there is an accident, the first thing that happens in an accident, what happens in an accident? मैले भन्नु त सायद यहाँ पुलिस अफिसरहरू हुनुहुन्छ, तपाईहरुले ज्यादा जान्नुहुन्छ है, कसैले पनि उभिएर भनिदिनुहोस् न त। के हुन्छ लु भन्नुहोस् त? भइरहन्छ एक्सिडेन्ट होइन त? तपाईहरु वहाँ त्यहाँ पेट्रोलिङ ड्युटी हुँदाखेरि पनि भइरहेको हुन्छ। के हुन्छ लु भन्नुहोस् त? एक्सिडेन्ट भयो अरे कसैले पनि भनिदिनुहोस् न त?
फर्स्ट अफ अल सर एक्सिडेन्ट हुन्छ
जी
तपाईले अघि नै भन्नुभएको जस्तो हिट एन्ड रन केस
हजुर
हिट एन्ड रन केसमा चाहिँ हामीले सपोजली हेर्दाखेरि फर्स्टमा दोषी तपाईले ड्राइभरलाई मात्रै थलाउँछ त्यसले हिर्काएर किन भाग्यो भन्ने हुन्छ सबैले। अन्त त्यो करेन्ट सिचुएसनमा चाहिँ अब त्यो ड्राइभरलाई भेट्यो भने पिट्नेसम्म हुन्छ, पिट्ने मार्नेसम्म सिचुएसन हुन्छ। त्यो ड्राइभर किन भाग्यो भनेर त्यो कसैले सोचेको हुँदैन। उसले आफ्नो बिचरा सेफ्टी खोजेको हुन्छ, उसले त्यहाँ बचाउने हस्पिटल लाने उसले सोचेको हुन्छ अरे ड्राइभर कतिले। तर त्यो स्पटमा तातो तातो खालको मल्लामा चाहिँ उसलाई मार्ने डर, उसलाई आफ्नो सेफ्टीको लागि भागेको हुनसक्छ। सेकेन्डली के हुन्छ, सबै मान्छे फेरि ड्राइभरहरू एउटा पनि हुँदैन। कतिले मान्छे मर्न आँटेको देखेर यो मर्दाखेरि म पक्रा पर्दिनँ भनेर आफ्नो सेफ्टीको लागि पनि भागेको हुनसक्छ। अब हामीले त्यो ड्राइभरलाई जस्टिफाई गर्नु बहुत साह्रो पर्छ कि ऊ इनोसेन्ट छ भन्नु पनि सक्दैन र ऊ इनोसेन्ट छैन भन्नु पनि सक्दैन। किन ऊ भागिसकेको हुन्छ, उसको नाम याद हुँदैन, इभन कति जग्गा त अब गाडीको भेहिकल्सको नम्बर पनि थाहा हुँदैन। अन्त त्यहाँनिर जुन चाहिँ स्पटमा भइसकेको मान्छेले चाहिँ प्रब्लम चाहिँ अब पुलिसलाई नै पार्छ। पुलिस त यस्तै अन्तर्यामी कोही हुँदैन कि जसले अब त्यो स्पटमा गएको कि यो मान्छे यस्तो यस्तो यो गाडी नम्बर यस्तो भने झट्टै त पक्रिन सक्दैन। त्यो तातो मल्लमा पुलिसलाई पनि सेफ्टी हुँदैन त्यो जग्गामा जानु। इभन युनिफर्ममा पनि त्यस्तै खालको बिहेभियरहरू हामीसँग गरेको छ है। हामीले अब नर्मल्ली इन्ट्र्याक्ट त गर्नु पऱ्यो। नर्मल्ली इन्ट्र्याक्ट गर्दाखेरि अहिले मान्छे निकाल्नु भन्छ। त्यस्तो सिचुएसनहरूमा धेरै प्रब्लमहरू पर्छ। सेकेन्डली के हुन्छ भने पब्लिकलाई अब युनिफर्म देख्दै अब कुनै पनि विटनेस एक्वायर गर्दाखेरि बस्नु मान्दैन होइन, डराउनुहुन्छ। हामीले लोयली बोल्छौँ, हामी अब कुनै पनि प्रब्लम नपारिकन पब्लिकसँग बोल्दा उहाँले डराउनुहुन्छ। कोर्ट भन्ने बित्तिकै कोर्टमा त कोही जानै मान्नुहुन्न। अब विटनेसको यति साह्रो प्रब्लम हुन्छ, विटनेस त अब चाहे सर त्यति बेला कति सिचुएसन त्यस्तो खालको हुन्छ जो प्र्याक्टिकल्ली गर्दाखेरि रेनी सिजन हुन्छ, रातिको 10 बजी 11 बजी 12 बजी राति हुन्छ इन्भेस्टिगेसन गर्दाखेरि। त्यति बेला अब लाइटको त्यहाँनिर प्रब्लम हुन्छ, त्यहाँनिर भिडियोग्राफीहरू गर्दा पनि हामीलाई धेरैवटा प्रब्लम हुन्छ। अहिले जुन चाहिँ सक्षमले अहिले अनलाइन भिडियो गर्नुपर्छ सर, हौ त्यस्तोमा हामीलाई धेरैवटा प्रब्लम हुन्छ। अब त्यो प्रब्लमहरूको समाधान अहिलेसम्म कसैले प्रुभै गर्नुभएको छैन। अब कतिवटा एभिडेन्स हामीले कोर्टमा गर्दा फेल खान्छ। अन्त सेकेन्डली थर्डली के छ भने विटनेस अब हामीले जति बेला चाहेको हुन्छ कोही बस्नु विटनेसको चाहिँ एकदमै प्रब्लम हुन्छ।
हजुर, उहाँको कुरा कोर्ट केसेसको छ है। र मेरो प्रश्न के थियो भन्दाखेरि सरले एकदम ठिक कुरा गर्नुभयो, तर एउटामा चाहिँ आई विल डिफर विथ यू कि हिट एन्ड रन केसेसमा if there is a mob attempting to beat up the driver, र त्यस्तो केसेस चाहिँ hit and run cases भन्दैन। Hit and run cases are those where the driver is not identifiable at all, the vehicle is not identifiable. हिर्कायो कसले हिर्कायो थाहा छैन, तर मोब एट्याक गर्ने गाडी पनि छ भने चाहिँ दिस आर थिङ्स विच यु नो गाडी योले हिर्काएको रहेछ होइन, ड्राइभर भागेछ, अल राइट यु आर नट एबल टु आइडेन्टिफाई द ड्राइभर, तर गाडी त आइडेन्टिफाई गऱ्यो नि त। सो दिस विल नट कम इन हिट एन्ड रन। बट माई क्वेसन इज, it's a very simple question. If there is an accident, what is the first thing that a police officer does? Accident भयो अरे, नर्मल एक्सिडेन्ट है यो हिट एन्ड रन केसको होइन, कहीँ पनि एक्सिडेन्ट भयो, फर्स्ट थिङ तपाईँहरूले के गर्नुहुन्छ त भन्दाखेरि कसरी सुरु हुन्छ भन्नुहोस् त इन्भेस्टिगेसन?
सो फर्स्टली त हामीहरू पर्मिसन लिन्छ एसएसओ सरको। एसएसओ सरले डाइरेक्सन दिनुहुन्छ कि यो जग्गामा एक्सिडेन्ट भयो र गएर चाहिँ इन्भेस्टिगेसन गर्नु। त्यसको बादमा हामी जिडी लेख्छौँ, डिपार्चर लिएर पुलिस टिम त्यो जग्गामा छिटोभन्दा छिटो पुग्छौँ। पुगेर फर्स्टमा टाइप अफ एक्सिडेन्ट कस्तो खालको छ, सेकेन्डली इन्जुरिज कति छ, फर्स्टमा त इन्जुरिज पर्सनको आइडेन्टिफाई गर्छौँ, उसको गार्जियनलाई कन्ट्याक्ट गरेर त्यहाँ बोलाउने या त्यस्तो प्रकारले इन्जुरिज भयो भनेर उसलाई फर्स्ट एड्स एकदमै झट्टैभन्दा झट्टै कुनै भेहिकल्स मगाएर उसलाई हस्पिटल पुऱ्याउँछौँ। उस हस्पिटल पुऱ्याउँदाखेरि हस्पिटलबाट अब नेक्स्ट टिमलाई हामीलाई त्यहाँनिर उसको डिटेल्स र अब गार्जियनको डिटेल्स हस्पिटलमा उठाउनु भनेर उसलाई चाहिँ फर्स्टमा हस्पिटल पठाइहाल्छौँ। सेकेन्डली चाहिँ अब इन्भल्भमेन्ट अफ भेहिकल्स, कुन भेहिकल्स इन्भल्भमेन्ट छ एक्सिडेन्टमा त्यसको डिटेल्स, ओनर्सको डिटेल्स त्यसपाटि जान्छौँ। ओनर्सहरूको डिटेल्सहरू सबै लिइसकेको बादमा त्यहाँदेखि हामी त्यस्तै प्रकारले केस प्रिपेयर गर्छौँ।
यहाँ सर तपाईँ जोडसँग भयो नि सर, पार्किङ भयो, उहाँले कुरा ठिकै गर्नुभयो होइन। The first thing that happens whenever there is an accident is a report. Yes, everyone marks the police do not have eyes and ears everywhere. They will not be able to say then and there who is wrong and who is right, and that will depend on the course of investigation and the findings later on. But the first thing that happens is whenever there is an accident is if there is any injury, the local people there itself will try and take that injured to the hospital, number one, survival level. And the second thing that they will do is they will report it to the nearest thana. Once there is a report in the nearest thana, there is a GD entry and there is a registration of FIR. One team going to the spot for verification and for helping the injured is another matter. But to take this accident into its logical consequence, the report is registered as an FIR in that police station. Normally, 279 IPC right? Rash and negligent driving accident. That is the presumption. So there is a registration of a rash and negligent or accident case in your thana. Like Sergey Hon'ble, SHO directs one of the subordinates to go to the place of occurrence as the investigating officer. The one is investigation sort of person. So this is the regular course that is taken. The IO goes there, he will try to find out ko raisa, ke raisa, and ke bhayecha, statement record garcha, 161. The vehicle is seized. There are 2 witnesses called for seizure memo. The seizure memo is prepared. NLC, you give it for the injured, or if there is death, you request for post-mortem, you will take a post-mortem report. The statement of witnesses are all recorded in the old CRPC under 161. And later on, it will depend on the type of case and the number of or the work that you have in your concerned police station. However, if it is a heavy load police station, there is delay in filing the charge sheet. 173 at the end, 173 of the old CRPC, there is a report, a final report, which is also known as charge sheet. The person is identified, courtman, pathaideu in the court of Chief Judicial Magistrate for trial. So this is the common course of action that is taken whenever there is an accident. But what has 150A? As I was saying, what has 150A brought about? What change has it brought about? Now the course of investigation कसरी गर्नुपर्ने, कस्तो प्रकारले गर्नुपर्ने 150A ले बताएको छ. Like I said, this is one of the longest, perhaps, provision under this rule, and it gives you a comprehensive list of what is to be done. हाइवेले मात्रै होइन, गाडी मालिकले मात्रै होइन, victims family मात्रै होइन, insurance companiesहरूले मात्रै होइन, तर claim tribunalले पनि. How are we going to handle these kind of cases? Number one, the IO, they will have to go to the site for inspection. Certainly one must take photographs, videos, and certain say to upload it in their software. These are things that don't take it as a problem, take it as a challenge. And the more you want, because see, things you have no choice, we have to adopt. We have to adopt and we have to adapt. Our BNSS has come in from 2023. It mandates that whenever there is an investigation, you take video, you take audio. And incidents do not occur with a calling. खबर नभई हुन्छ नि त, कोही बेला 12 बजी हुन्छ, कोही बेला 1 बजीको राति हुन्छ, but as a police officer you have to go there, and the BNSS mandates that you have to take video and audio, and you have your app. अहिले त NIC ले डेभलप गरेको एप छ where you notify पनि भएको छ होम डिपार्टमेन्टबाट, where you have to upload through your mobile phone in that particular app with time, geographical indication, सबै दिएको हुन्छ नि त त्यसमा। र 150A has to be read for investigation with BNSS or even BNS. You'll have to take video, you'll have to take audio, take the layout of the road, the width, which you normally do, and record it. In injury cases, what do you have to do? Take photographs of the injured in the hospital. You very कमले गर्छ, तपाईले याद गर्नु होला। I think it is very important. Injured लाई उता त पठाइयो, थाना त पठाइयो, किनभने the whole mental outlook of an investigating officer is only from the perspective of solving that crime. उहाँले त क्रिमिनल केसको एङ्गलबाट मात्रै हेर्यो नि त, till now, हैन? इन्जर्ड छ, हस्पिटल पठाइयो, फोटो किन चाहियो? मेडिकल रिपोर्ट छँदैछ। Whenever he has to come to the court, he is the injured, he will not lie. He will say that I was injured here, my hand broke, this happened, that happened. So what the investigating officer does is, they don't take pictures. Why is pictures important? Because you have to see from the other perspective, other angle of compensation by the legal representatives. Family, whenever they apply for compensation, these things are required in the claims tribunal. You take their statement. Second, what do? You have to give an intimation about this accident to the claim tribunal within 48 hours. But by 2019 amendment, and this is mandatory. I have seen, mostly I see accident report from Singtam Thana, I see accident report from Sadar Police Station. Within 48 hours, it comes to the claim tribunal. With what? With FAR. What is FAR? First accident report. Here the first accident report. There is a form. I know if you want, I can share that form with you all. There is a form. It looks something like this. FIR number, date, kukusa details. All you need to do is fill it up, and with a copy of the FIR, you send it to the claim tribunal within 48 hours. Now when you go there, when you seize the vehicle, what do? When you seize the vehicle, you will also seize the documents. Gadi ko chabi, driving license, kosko chhabni, ya gadi ko kagaz patraharu, tabaile sabai seize garनुहुन्छ in that particular seizure memo. When you seize the documents of a vehicle, you will naturally come to know if there is an insurance. If there is an insurance, you will have to give this intimation of this accident also to the nodal officer of insurance company. Yeah, police officers are हजुरहरूले याद गर्नुहोला कि हरेक insurance company को nodal officer छ. They have already given the list of nodal officers, which I can share it with you. I have it in my laptop as well. But nodal officers को phone number, email addresses. The insurance company has been mandated to share with the claims tribunal, the registering officers, as well as the police stations. Now, they will have to, the IO will have to share this information also to the nodal officers of the offending vehicle. Along with that, you will also have have the mandate to give it to the State Legal Services Authority. र तपाईँहरूको मनमा प्रश्न हुँदैन कि स्टेट लिगल सर्भिसेस अथोरिटीलाई चाहिँ किन दिनु भनेर? हुन्छ कि हुँदैन भन्नुहोस् त? होइन, दिज आर थिङ्स विच कम अप इन योर माइन्ड अभियसली. यसैबाट के हुन्छ भन्दाखेरि दे विल प्रोभाइड लिगल एड टु द विक्टिम, द फ्यामिली, इफ इट इज रिक्वायर्ड. And whenever there is a state police portal with an app, you have to upload it there. I do not know whether Sikkim Police has as of now, but what we get is a physical copy. हाम्रो online system अहिले डेभलप भएको छैन, र त्यसले गर्दाखेरि हामीलाई physical copy चाहिँ आउने गर्छ. Number 3, what does the IO do? You will have to furnish the description of the rights of victims. एउटा फ्लो चार्ट छ, त्योहरू पनि तपाईँले फर्म 2, अघि मैले फर्म 1 देखाएँ, फर्म 2, फर्म 3, यस्तो धेरै फर्म छ, ताकि सो द्याट देयर इज युनिफर्मिटी. एउटा आयोले एउटा सिस्टम अडप्ट गर्यो, अर्को आयोले अर्को सिस्टम अडप्ट गर्यो, बङ्गालमा जाँदाखेरि एउटा सिस्टम अडप्ट भइरहेको छ, होइन, महाराष्ट्रमा जाँदा अर्को सिस्टम छ, सिक्किममा अर्कै छ. In order to bring uniformity, they have also given you the forms. Your form are not so tough. It will be easier for all of you. So you have to furnish this flowchart within 10 days. And this form you will have to enclose it with your detailed accident report, which you will be filing to the claims company. There is a driver form to be submitted by the driver. गाडीको ड्राइभर आइडेन्टिफाई भयो, उहाँहरूलाई फर्म 3 मा उहाँको डिटेल ड्राइभरले आइओलाई दिनुपर्छ. उहाँको नाम, उहाँको ड्राइभिङ लाइसेन्स छ भने ड्राइभिङ लाइसेन्स नम्बर, उहाँको ठेगाना, all these within a period of 30 days of the accident. There is also another form, Form 4, for owners. गाडी मालिक को होता, उहाँको registration certificate, permit, all these documents, the details have to come in Form 4 to be sent to the IO within 30 days. किन भन्दाखेरि अहिलेसम्म चाहिँ IO have to run behind them, होइन? आयोले उहाँलाई खोजेर, गाडी मालिक खोजेर यता यति गर्नु. But now there is responsibility on the driver, and there is a responsibility on the owner as well to provide these details to the investigating officer. Why do they require these details? They will have to put it in the detailed accident report or DAR in order to give it to the claims tribunal and also to the nodal officer of the insurance company. 6th, I'm going chronologically. The interim accident report will have to be submitted by the IO to the claims tribunal within 50 days. 50 दिन भित्रमा तपाईहरुले फर्म 5 मा interim accident report. पहिला त फर्स्ट एक्सिडेन्ट रिपोर्ट दिनु भयो नि त. First accident report was just that FIR, which is already there in your Thana. Now you are giving an interim report with what? With the driver's detail, with the owner's detail, and so on and so forth within 50 days. Almost 2 months. It will be accompanied by what? Copies of the IR. Rayora copies it apparently. You will also have to give it to the State Legal Services Authority. And to the insurer, General Insurance Council पनि भनेको छ. But what happens once the insurance company gets these details? अघि तपाईहरुले शेयर गर्नुभयो नि त यो डिटेल्सहरु with the insurance company. Now it mandates that the insurance company will have to verify whether the insurance is correct, whether it is proper, so that the IO can file their DAR. Number 8, Form 6 जुन चाहिँ छ victims को. अघि त ओनर ड्राइभर को भयो, अब यहाँ victim भयो नि त. Singular victim or many victims. you'll have to give their information, naam, Thegana, all these information, kind of injury, because by that time, by 60 days or by 2 months, you will have come to know what kind of injury. And first responder, the first treatment by 2 months, now you sort of get to know what kind of injury is this. If it is an ongoing treatment, you can also mention that. And in Form 6, you will have to give within 60 days from the day of accident the details of the victim or the victims. 9. If there are minor children of the victim, doesn't mean that minor children will have to be involved in an accident. The key ko lagi, your criminal case ko lagi, right? This is for the purpose of claim. Agar nani haru cha bhane uहाँहरुको पनि details the RU have to collect, and they will also have to give it not only to the claims tribunal, but they will have to give it to the CWC, Child Welfare Committee. Child Welfare Committee there is Child Welfare Committee in our state as well. Why do Child Welfare Committee require these kind of details? Rule 150A को sub rule 9 सम्म discuss करें. Don't you think that there is a lot of stakeholders that are being brought into one umbrella? पहिला यस्तो थिएन नि त. पहिला nobody knew what was going on. Claims tribunalलाई केही थाहा छैन, insurance companyलाई पनि केही थाहा छैन, CWCहरू भनेको सुनेकै थिएन. When you give it to a CWC, the CWC will verify whether that child is in need of care and protection under the GG Act. And if so, they will deal it accordingly under the Juvenile Justice Act of 2015. अहिलेसम्मको जति पनि डेलिब्रेसन्स हुँदैछ, is it all right or not all right? Right? Or should we go in this way or that way? If you have any suggestions, you please let me know so that I can modulate my presentation accordingly.
Excellent,
sir. Because at times when we go too much in details, people they find it a little monotonous at times. But I think 150A of the CMV Act, CMV rules, though it is detailed, these are very essential. When I was telling you about sub-rule 9 that time about CWC, why do you have to submit this form, a copy of this form, to the CWC? Because CWC may ascertain whether that child is in need of care and protection. And why do we give it to the why do we give it to Sikkim State Legal Service Authority? Is because if required, they will engage a legal aid so that this child will have their legal remedies, education, so for all these things, the IO is required to give one copy of the DAR to the CWC and the State Legal Services Authority. Number 10. Once the insurance company gets these information, what you are required to do is you are required to verify and then confirm that the insurance papers are all right, it is a valid insurance, and then you give it to the IO within 30 days from the receipt of the detailed accident report. And investigation 279 गाडी एक्सिडेन्ट केसेसहरु इन्भेस्टिगेसन कति दिन भित्रमा बुझाउनुहुन्छ चार्जसिट भन्नुस् त how long do you take to submit a charge sheet? 90 days हैन So sometimes it's 90 days, sometimes it goes little beyond 90 days according to circumstances. But 150 rule, 150A rule mandates, now it has to be done in 60 days. तपाईँहरूले 60 दिनभित्रमा you will have to complete your investigation and then you will have to file your charge sheet. Or in the words of CRPC, the final report under 173 before the jurisdictional criminal court. So this is one essential feature that the investigating officer will have to take note of. Now, what do you do? Another thing. The detailed accident report will have to be submitted by the IO to the claims tribunal within 90 days with all these information. अघिको जुन चाहिँ हामीले information माग्यौँ नि, from the driver, from the owner, from the minor child, from the insurance company, from the victims, योहरू सबै हामीले gather गरेर you will make a detailed accident report and file it before the claims tribunal within 90 days. What will DAR be accompanied with? DAR मा के हुनुपर्छ भन्यो भने you will have to keep in mind site plan. फर्मै छ, Form 8 भनेर. Mechanical inspection report. हाम्रो MVI सरहरू हुनुहुन्छ हैन, MVI म्याडमहरू हुनुहुन्छ. Form 9. Verification report. यो जति पनि अघि थियो. Form 10. र charge sheet को copy. The form छैन, a charge sheet copy will have to be accompanied with your DAR. Along with one copy to the claims tribunal, the IU will have to give one copy to the driver, the owner, and the victims, apart from the insurance company and legal services authority. कोही बेला के हुन्छ त भन्दाखेरि the IO is unable to prepare this DAR on time. IO को पनि भनेको बित्तिकै कसैले दिँदैन नि त. कोही बेला खेदाउनु पर्छ, कोही बेला घरिघरि फोन गर्नुपर्छ. र त्यति बेला इन्भेस्टिगेटिङ अफिसर्सहरूले हाम्रोमा चाहिँ के चाहिँ छ र यस्तो कि प्रावधान जहाँ चाहिँ हामीलाई रिपोर्ट दिएन भने हामी के गर्न सक्छौँ भन्दाखेरि इफ यु गो टु सब रुल 14 you can seek direction from the claims tribunal. अगर ड्राइभरले, गाडीको मालिकले, इन्स्योरेन्स कम्पनीले र क्लेमेन्टले इन्फर्मेसन तपाईँहरूलाई डिस्क्लोज गरेन, डकुमेन्ट्सहरू यो मागेको तपाईँले दिएन भने you can bring this to the notice of the claims tribunal. र claim tribunal ले के गर्छ? The claim tribunal will direct the concerned authorities to file it within 15 days. Clause 15 gives a mandate to the RTOs, registering authorities. तपाईहरुले के गर्नुपर्छ? You will have to verify the documents. IO ले त उहाँहरुको काम गर्नुभयो. In one form they have given you a copy. लाइसेन्स दिनुभयो, तपाईहरुलाई परमिटको कपी दिनुभयो, तपाईहरुलाई RC बुकको कपी दिनुभयो. So it is the registering authority to verify these within 15 days from an application made by the IO. र इन्भेस्टिगेटिङ अफिसरले यो पनि तपाईहरुले मान्नु भएन, यो मनमा राख्नु भएन कि हस्पिटल जाँदाखेरि त हस्पिटलले यादै गरेन, हस्पिटलले कोअपरेटै गरेन भने त्यसकोमा पनि there is a provision now. It is a mandate, a duty of the hospital to issue MLC, medical legal certificate. जुन चाहिँ medical legal case को certificate हुन्छ, it is for them to give it. Postmortem को पनि तपाईहरुले दिनुपर्छ, कहिले 15 दिन भित्रमा आयोलाई दिनुपर्छ. In case the IO is unable to file his DAR on time or IAR on time, what can you do? You can approach the claims tribunal, ask for extension of time. Claim tribunal will look into your matter and if required will give you more time to file your either IAR, which is to be done within 50 days or your DAR.
अब इन्भेस्टिगेसनको रोल खत्म हुँदै आयो. Now what happens? Now the ball is in the court of the claims tribunal. Claim tribunal ले त यो सबै पाए नि त रिपोर्ट्सहरू. Now it is for the claims tribunal to take action, react. I do not know whether the other colleagues of mine are joining through VC, but we have one member of the claim tribunal from Namchi. उहाँले के गर्नु, हामीले के गर्नुपर्छ भन्दा we examine the FAR, the first accident report, the interim accident report, the detailed accident report, whether it is complete in all aspect. Now if it is complete, we will fix a date for appearance of who? The driver, the owner, the claimant, eyewitnesses if there is any. And once a direction is given, it is the IU who has to produce them. IU ले के गर्नुपर्छ भन्दाखेरि IU will also have to give an information to the nodal officer of the insurance company.
Yes, sir.
That, yes sir.
Please, I am computer solved.
Sir, the mic दिनुहोस् न.
Almost what I have seen, I came across with my case, MECT. So most of the police, what they do? They submit FAR, is okay. Then subsequently, TAR will register or summon to the injured person. I don't find any details.
So, say example, in accident there are some other persons also who got injured. In that they report simply, they will give the name of the one person and others. I don't know how to issue. I asked so many times to the consular because the IO doesn't come and they send some constable with this. When I look into and I will ask that question, they are playing, they don't know. One aspect. Another is I find there are some family members injured, and what they do, they just give the details of one senior person or father something and other dependent, and how to issue someone to the other person. How you know? This is the all police officer. This is the lacking. I don't know because of the need training or something information. I think you all would say you should keep details at least. Even I didn't find sometimes the address. We issue the address. Sometimes I don't know in driver as per the driving license they will put the address, but driver doesn't stay in particular place. They will go somewhere else and then you only issue the notice or something to the driver. They won't come. It's going time and again I have to call the IO, this, that, all these things. You at least during investigation, which all the police remind me, you please get the details of the driver and other address. Who are the injured person, the address of the injured person and driver, so that matter will be taken up expeditiously. Now it's going on 1 month, 2 months, girls find out the driver and other injured person, they don't. That's what I have to say. Please ensure that the details of the everything in the car.
That is quite obvious. Even when I take up matters, I notice. You know, why is this? It is not because the investigating officers or the police officers, they don't want to. होइन? किन हो भन्नुहोस् त? मलाई लाग्छ, it is because the investigating officer is investigating the case purely from the angle of a criminal case. मेरो काम त यो केसलाई चार्जसिट फाइल गर्नु मात्रै हो नि त. यो एङ्गलबाट चाहिँ हेरेको हामीले छैन अहिलेसम्म, होइन? Why is the information about the owner of the vehicle or the driver of the vehicle or the victims not coming forth? It's because number one is we are not aware नि, होइन सर? फर्म छ अलरेडी. हामीले अब चाहिँ के गर्नु पर्यो भन्दाखेरि we are required to get ourselves familiarized. हामीलाई यो कुराहरू जानकारी हामीले दिनु पर्यो. होइन हजुरहरूको साथीहरू छ भने उहाँहरूलाई पनि इन्फर्मेसन दिनु पर्यो र म त यो पनि भन्छु कि एकाडेमी यहाँ सरले थ्रु एकाडेमी हुन्छ कि या तपाईँहरूको पुलिसको फाल्टै ट्रेनिङ हुन्छ यु अल सुड बी मेड अवेर कि हामीले चाहिँ यो 150A द प्रोभिजन्स अफ 150A नाउ हेज टु बी अप्लाइड in letter and spirit. Once we do that, there is no fail. What the claims tribunal require, they will get all the information. Sir, भन्नुभएको ठिकै हो नि त Mr. X and others भनेर आउँछ हो others भने को हो कोही थाहै हुँदैन हैन र these are things which if we take notice of that particular form where we can get the information of that driver, information of the owner, information of victims, these things will not arise at all. And we go back to the topic. Now once you intimate the insurance company, they will also have to come on a date fixed. What happens if the IO do not complete it, or when the claim tribunal sees and they feel that completed छैन रहेछ यो भन्यो भने they will direct the IO to complete it and file it again. र claim tribunal को परिस्थिति त्यही हुन्छ कि who is going to bring the driver, who is going to bring the owner. Now clause 19 mandates that it is the investigating officer's duty to produce the driver, owner, claimant and eyewitnesses before the claims tribunal. तर कोही बेला के हुन्छ भन्दाखेरि if the IO is unable to bring them, हैन, because there are things sometimes beyond his control. कोही बेला विटनेस भेटिँदैन त्यो मान्छे, कोही बेला ओनर त्यहाँको हुँदैन, they are from the jurisdiction outside सिक्किम, बाहिरको हुन्छ, त्यति बेला उहाँले फेरि एक्सटेन्सन माग्न सक्नुहुन्छ, not later than 30 days. IO will also have to give an advance notice to the nodal officer of the insurance company कि यो दिन चाहिँ मैले डिटेल एक्सिडेन्ट रिपोर्ट फाइल गर्दैछु है क्लेम ट्राइब्युनलमा भनेर र so as to enable that nodal officer of the insurance company to be present in the court when that DAR is filed on that day. र यहाँ सरले अघि भन्नुभयो कि the police officers are not doing their duty, हैन, तपाईहरुले यो नमान्नुहोस् है कि तपाईहरुले ड्युटी गरेकै छैन भनेर. मैले यो take it as a hypothetical statement, but it happens. यहाँ सरको कोर्टमा पनि कतिवटा आएको रहेछ कि there are no details, हैन. Once we ask them to bring the witnesses or we issue summons through the IO, but the claimants are not there, the vehicle owner is not there, the summons are not returned. So what do we do? Clause 20 mandates that it will be a part of the State Police Act. Hamroma Second Police Act cha. And if you don't do your duty, it will be dereliction of your duty, and the concerned State Police Act can be invoked. The IO till now अहिलेसम्म चाहिँ तपाईहरुको जति पनि यस्तो प्रकारको केसेसहरु हुँदै थियो म्याजिस्ट्रेटको कोर्टसँग सीमित थियो नि त, हैन, र अहिले यसको दायरा बढेर अगाडि गएको छ. र अगाडि जाँदाखेरि चाहिँ के हुन्छ भन्दाखेरि इन द क्लेम्स ट्राइब्युनल द इन्स्योरेन्स कम्पनी दे आर अवेयर अफ दिस, बट आइओ साहबहरुलाई जानकारी कि मोटर भेहिकल एक्ट 1988 मा एक्सिडेन्ट हुँदाखेरि या त इन्जर्डले या त मरेको उनको फ्यामिलीले they can file a claim application under two provisions. One is known as under 166. एउटा section 166 मा उनीहरुले claim application फाइल गर्न सक्छ. त्यसको रिक्वायरमेन्ट के हो भन्दाखेरि गाडी लापरवाहीसँग कुदाएको कारणले गर्दा एक्सिडेन्ट भएको हुनुपर्छ भने दिस इज वान रिक्वायरमेन्ट। र उहाँको डकुमेन्ट्सहरू सबै हेरेर इन्स्योरेन्स कस्तो प्रकारको छ, वेदर इट इज कम्प्रिहेन्सिभ इन्स्योरेन्स, वेदर इट इज एक्ट ओन्ली पोलिसी अर लाइबिलिटी ओन्ली पोलिसी, यो हेरेर उहाँको एज हेरेर उहाँको इन्कम हेरेर देयर इज अ स्ट्रक्चर्ड फर्मुला र त्यो स्ट्रक्चर्ड फर्मुलाको मुताबिक उहाँलाई कम्पन्सेसन दिने गर्छ अन्डर 166। र अर्को हुन्छ विच इज नोन एज नो फल्ट लायबिलिटी 164 मा, सेक्सन 164 मा उहाँहरूले एप्लिकेसन फाइल गर्न सक्छ। र त्यसमा के हुन्छ भन्दाखेरि गाडी अगर लापरवाहीसँग कुदाएको कारणले गर्दा पनि एक्सिडेन्ट भयो भने इरेस्पेक्टिभ अफ नट विथ स्ट्यान्डिङ भनेर सुरु हुन्छ 164 को सेक्सन नन अब्स्टिनेट क्लज भनेर नि। र गाडी लापरवाहीसँग कुदाएको छ भने पनि देयर इज अ टोटल अमाउन्ट 5 लाख इज द म्याक्सिमम। 5 लाख उहाँलाई दिन्छ इन केस अफ डेथ, इन केस अफ फेटल इन्जुरिज, इन केस अफ इन्जुरिज 2,50,000 is the provision under 164. So these are two sections, two provisions जहाँ चाहिँ compensation claim गर्छ claim tribunal मा नि त। र once the claim tribunal gets all these information from the IO in the form of a DAR, the claim tribunal have the option to register it as a claim application under 166 clause 4 money. At times when the party is required, उहाँहरूले होइन हामी सेपरेट क्लेम एप्लिकेसन फाइल गर्नु पर्यो, we don't want to continue with this matter which the IO has filed it as a detailed investigation report, but we have got in touch with our lawyer. Now we have also prepared one application under 166, so please treat this application as 166 or 164, whatever it is, our application Mansanta. So in that case, the claim tribunal have to tag along this miscellaneous case along with the DAR. This is one thing you'll have to see. Ra, if the DAR is treated as 166, the question of negligence will come. Gadi, लापरवाहीसँग कुदाएको हो कि होइन, एक्सिडेन्ट लापरवाहीसँग भएको हो कि होइन भन्दाखेरि the charge sheet will have to be gone through if there is, and if the claim tribunal is satisfied, then an award can be passed. This is what the claim tribunal does. हाम्रो कोर्टमा यही हुन्छ। FAR को miscellaneous जुन चाहिँ केस हुन्छ, this will be tagged along with the main application. Again, you will have to register 166 if there is rash and negligent driving, if you are satisfied. If not, then under 164, as I told you, this is a no fault liability. Now what happens thereafter? The insurance company will have to appoint a designated officer within 10 days from the receipt of detailed investigation, detailed accident report. Why do we appoint a nodal officer? So that the nodal officer from the insurance company can go, can verify, and what you can do is, based on your norms, you can give a quote. We can compensate this particular case with this particular amount भनेर नि त उहाँहरूले दिनु सक्नुहुन्छ after you verify your claim. Why is verification required by the insurance company? Because at times there are fake accidents also, right? All over India, not all charge sheet is 100% correct. There are many cases where just for this compensation, they file an application under 166. Fake cases are हुन्छ। So the insurance company will have to verify whether the DAR is okay or not. Now if you find that the IO's DAR is not correct,
You have an option to go to the Deputy Commissioner, which here in our case is SDPO or SP, and file your objection there. You can also call for the CDR, call details of the driver. Now if you take a decision that no, we are going to compensate, and if the quantum is agreeable, you can take a decision within 30 days. And if you don't admit your liability, कतिवटा contest हुन्छ नि in the Motor Accident Claim Tribunal, not all cases are accepted by the insurance company, but I think 99% cases are contested. You will have to disclose your ground under this form. Why do you want to contest? Why don't you want to admit your liability? When there is a consent from both the parties that the compensation that has been quoted by the insurance company is acceptable to the family of the or the legal representative of the deceased or that injured person or the applicant, within 30 days you will have to deposit that award with the claims tribunal. What is the duty of the claims tribunal? You will have to see whether that compensation amount is just. Why just? Because the Motor Vehicle Act of 1988, particularly 166, 164, these are based on the law of tort. हाम्रो जब कानुनको छ, the whole act or this provision is based on the law of tort कि if there is a fault, there will be remedy. If you see your legal magazine, it is known as ubi jus ibi remedium. Where there is a fault, there will be remedy. So it is for the claims tribunal to see whether it is just or not. And if the claims tribunal feel that it is all right, compensation within 6 months, the consent award will have to be passed. Now it doesn't stop here. Prior to in 166, when an application filed, once there is a consent award, if there is contest or no contest, whatever it is, the duty of the claims tribunal is over. But now 150A goes a little ahead to find out and to mandate what is the duty of a claim tribunal. This is the time. In case of non-settlement, this is another provision. This is a provision under clause 30 where the insurance company disputes the liability. I had already mentioned about this. Before passing an award, the claim tribunal will also have to look into this aspect, that the DAR is correct, examination of the claimant before we pass an award if required, and the mode of disbursement will be kept in fixed deposit. It will be the duty of the claim tribunal to see that before disbursement, these documents are on record. Aadhaar card, PAN card, linked documents, so on and so forth. This is another, wherever there is a written submission to be filed, and this is the deposit of the amount. It has to be done within 15 days with the overall interest that has accrued till date. How is this disbursement to be done? We go one step ahead. The claims tribunal will have to now find out the mode of release as to how you want to release. Now, one way is to protect that award
You can either release entirely or you can release in part. You can keep one of the major chunk in fixed deposit or in the annuity deposit scheme, which is stipulated in this particular form. Now, the other thing is how do you deal with compliance? There is a provision under 37 that whenever there is an award passed, once the compensation is made out, given, you will have to incorporate this in this particular form. This is for the claims tribunal. The work of the IU, the other stakeholders is over. Now it is the claims tribunal. Now you'll also have to fix a date for reporting compliance, calculate the interest, so on and so forth. Now the other topic that is here is how do you execute? Koi bela bhayena, compensation is given, but the insurance company has not deposited, or the owner of the vehicle has not paid the money at all. If it is not done even after 90 days, the claims tribunal can execute the award under 169. 169 will keep on saying, you will have to see the, I'm sorry, perhaps many of these is technical, but it is required. How do you execute your decree? Hamro civil cases ma, once the court decides a case, the final order is known as decree. This particular decree is executed under the Code of Civil Procedure 1908 and Order 21. Order 7, this is the longest order in CPC. The Order 21, there is mode, how do you execute? Order 21, Rule 11, देखो हुन्छ मोड मलाई अट्याचमेन्ट चाहियो मलाई उसको कुर्की गरिदिनु उसको सामान बेचिदिनु भनेर चाहिँ then you give that money back to me. So these are the modes of execution. 169 says you can take the help of the provision of execution under the CPC and execute the award. The other one is 174. 174 says that if it is a land revenue from the collector, you can take it as a revenue for that land and execute the award. Now apart from that, it also mandates that if there is any decision, direction of the Honorable Supreme Court of India or the other authorities, the claim tribunal have to take into consideration these orders as well before you execute the award. अहिले हालैमा के छ भन्दाखेरि the mandate of the Honorable Supreme Court is that an execution has to be completed within 6 months. And this is one of the latest decisions which we all have to comply. Now what do? The Claims Tribunal will also give a copy of the award as well as DAR to the concerned criminal court. या त यहाँ magistrate को court मा case चल्दैछ भने this copy will go to them. One copy will also be sent to the Legal Services Authority. And then the Claim Tribunal will record the award under Form 18. And these are all things which the Claim Tribunal has to do. Now, what do? I mean, SLSA, Legal Services like the DO. Now the Legal Services Authority will have to prepare Victim Impact Report or VIR. उहाँको assets, उहाँको income, your study गरेर they will have to place it before the concerned criminal court within 30 days. ताकि के गरेको भन्दाखेरि all the stakeholders are being put under, as I said, one umbrella, so that everybody knows what is going on in this particular case. So I have come to the end
of my topic. Before I discuss one or two cases, is there any question? Hazurलाई ठिकै छ होला नि त? Is it all right? You have any questions? Okay. It will be very important for the investigating officers and also for the insurance company to take into consideration. These are provisions which we all have to follow. Okay. Now let us go to some of the practices. I cannot say best practices, but one thing. 1989, this is one case of the Honorable Supreme Court which mandated that every citizen involved in an accident will get treatment in the hospital, first response. No hospital can say no. Medical aid dinai parcha uhanhरुलाई, be it private, be it government hospital or be it private hospital. So this was the case which was in vogue until this particular scheme, the cashless treatment scheme, जुन चाहिँ छ त्यो विषयमा नि. To tell you about this cashless scheme, 164B talks about or mandates that there has to be a fund. Fund for what? As I told you earlier, for treatment during this golden hour, hit and run cases, if there is death, if there is injury, this fund will be utilized. But who's going to constitute or who's going to make this fund available? Who's going to frame the scheme? It is the central government. This amendment of 2019 was done by the Ministry of Road and Transport and Highways. They wanted this provision. Now it is a mandate on them to prepare a scheme. There is a case before the Honorable Supreme Court of India. You can follow this matter if you want. You know this site was in 2015 INSC 45 bane. This is a neutral citation. तपाईहरुले Supreme Court को website मा neutral citation हाल्यो भने पनि यो केस आउँछ. या त तपाईहरुले यो writ petition, sorry P छैन रहेछ त्यहाँ, that's a mistake. Writ petition, WP भने चाहिँ writ petition हो, case number 295 of 2012. This matter is pending in the Honorable Supreme Court of India for cashless facility. Golden hour ko ni. Now what happened is, on the 8th of January, just to give you a brief about this matter, the Honorable Supreme Court passed an order कि 24 March भित्रमा the central government, you will have to frame the rule. Sorry, you will have to frame this scheme. You will have to provide this fund. Cashless treatment or this golden hour treatment should not only be in paper, but it has to come in reality. Because if anybody wants to take advantage of this scheme, but if this scheme is non-existent at all, then what is the use? 24 तारिक भित्रमा चाहिँ scheme बनाउनै पर्छ भनेर there was an order on the 8th of January this year. But what happened on the 24th? In fact, this matter was taken up on 28th. हिजो अस्ति सोमबार Supreme Court मा केस थियो. There was a secretary of the Ministry of Roads and Transport. उहाँहरूले भन्यो हामीलाई अझै टाइम चाहियो भनेर नि. But the Honorable Supreme Court of India didn't take the request of the secretary in, but they provided time, and the ministry is now required to notify and place it before the Honorable Supreme Court within 9th. भन्नु मतलब यो Saturday सम्म र 13 तारिकमा चाहिँ यो केस फेरि सुनवाई हुन्छ भनेर नि. You can follow this matter. This is going on. So this is one thing which I wanted to tell you all. See, I must be candid about one fact, is that my presentation was, I prepared my presentation keeping in mind Motor Accident Claim Tribunal members, म जस्तो अरू मेम्बर्सहरू हुन्छ भनेर मैले आज यो मेरो प्रेजेन्टेसन प्रिपेयर गरेँ र कतिवटा डिटेलमा पनि थियो होला है र केसेसहरू पनि कतिवटा डिस्कस गर्दैछु र but I am sure that this will also be of some relevance and some importance to all of you. The other thing is it helps our members of the tribunal. To some extent, it will also clarify the doubts of the insurance companies. कारण के हुन्छ भन्दाखेरि 166 अहिलेको present provision, clause 3 says that a claim application has to be filed within 6 months. If it is not filed within 6 months, the limitation period is over. The parties are not allowed to file their application. But see this 1939 Act, which I was telling you earlier, Section 1110A, Clause 3 ma ke thiyo? There was a proviso. If you can satisfy the claim tribunal that you are prevented from filing it because of some cause, some sufficient cause, the claim tribunal had the discretion to allow, even if it was beyond 6 months. Your proviso nikaldeko cha ni ta aile. Have you noticed? There is no proviso. There is no discretion given to the claims tribunal. So what do we do? Many of the cases were thrown out of the courts. Now there is one particular case of the Hon'ble Madras High Court which I found it quite interesting and quite innovative. And I would like to share with you this particular case of Malaravan Manerani. This is a order of the 18th August last year, 2023 ko August. The Honorable Court has taken 150A of the rules which I discussed with you into account and said that when now there is a provision already that you will have to, the IU has to undertake all these important tasks of providing IAR, FAR, DAR, final report under 173. Why not? Why do we need to file an application for condonation or delay? Limitation kina chahiyo? I found the reasoning which was given in this particular case very, very effective and very, very innovative. Wale ke भन्नु खोज्नु चाहनु हुँदैछ भन्दाखेरि even if there is an FIR already registered in a police station and that information has come to the claims tribunal, either electronically or like in our case, a copy has come, a copy of the IAR, that is itself sufficient to bring to the notice of the claim tribunal that a claim is preferred. Kina Manda, Section 166, Clause 4 says that the report of the IU filed DAR, IAR, this will be treated as a claim petition. And therefore now, using this provision, I think my colleagues can take a note of this case. It will be helpful when we decide an application for condonation of delay. Now, last but not the least, this is one case which is very, very important. Gohar Muhammad, agi hamro director sahabले पनि सुरुवातमा भन्नु हुँदै थियो. This is a 2018 case. And you remember what he said? He said, perhaps it is under, in paragraph 67 or 69, the Honorable Supreme Court of India has mandated that there should be this kind of awareness program, training program for the stakeholders. So that is the reason why we are having this program here. Can you all remember?
Yes.
So I think coincidentally Banoki, Koso Bano, I think this is the first such program in compliance to the Honorable Supreme Court's direction that we are having a program here in the academy. And they have chosen me as the resource person, the first resource person. And incidentally, this order, this judgment happened to be passed by none other than Honorable Justice J.K. Maheshwari, who was the former Chief Justice of our own High Court, and I happen to be his Registrar General. So it is, I think, with great pleasure that I can show this before all the participants, that under the Kuhar Muhammad case as well, the Honorable Supreme Court has mandated that 150A now has to be followed in letter and spirit, and the claims tribunal will have to take the DAR or the IAR or the FAR as a claim application under section 166 clause 4 and bring it to its logical conclusion. So this is all for the day from my side. If there is any questions, I will take it. Thank you all. SBI General Insurance को नोडल अफसर भन्ना हुनुहुन्छ, फोन नम्बर हामीलाई सेयर गरेको यो हो, उहाँको एड्रेस र कोर्टमा स्ट्यान्डिङ काउन्सिल को हुनुहुन्छ भनेर उहाँ वकिलको नाम पनि हामीले लेखेको छौँ है। बजाज अलायन्सको लागि को हो, श्रीरामको लागि अगर हामीलाई इन्फर्मेसन छ भने हामीले लगायौँ, छोलामण्डलमको लागि भन्ना हो, म्याग्माको लागि भन्ना हो, होइन, नेसनल इन्सुरेन्स कम्पनी आज हुनुहुन्छ होइन सर, नेसनल इन्सुरेन्स कम्पनी किशोर कुमार सुब्बा उहाँ हुनुहुन्छ नि होइन, नोडल अफसर हजुर हुनुहुन्छ, हजुर तपाईँ हुनुहुन्न नि है, ओके। Is there anybody who's a nodal officer here? From which? New India Assurance. Sorry? New India Assurance. Mr. Gautam Singh? Gurnam Singh. हेर्नुहोस् उहाँको नाम देख्नुभयो यहाँ। Mr. Gurnam Singh, is your phone number all right or is this?
Yes, sir.
Okay. See, so what we have done is we have compiled the nodal officer's name, and I think this will make it very, very easy. Let me show you if we have it here. This is our website, court website. You can just type in Google District Court Gangtok, like a District Court Namsi या जहाँसुकै तपाईहरुको आफ्नो डिस्ट्रिक्टको छ भने यहाँ तपाईले पाउनुहुन्छ र most probably we have given the name of our